Good afternoon, everyone. We're going to get started momentarily. If you're still grabbing your food, feel free to go ahead and get a good plate. The food is amazing today. Before I continue, actually, can we just give a round of applause to our Director of Events, Peggy Zamba, for helping us all throughout Diversity Week and making sure that we had wonderful lunches and dinner all week long. So thankful for her department and her assistants. This is our keynote. I'm so glad that we made it to this point, and I'm very honored and thankful to be able to introduce Professor McMurtry-Chubb. And I'd like to do her a little justice by reading a bit of her bio. If I was to read a full bio of her expertise and experience, it would be several pages long. But I just have a few paragraphs that I'd like to share with everyone as we get started before she gives us our keynote. Teri McMurtry-Chubb is a visiting distinguished professor of law at UIC John Marshall Law School. She researches, teaches, and writes in areas of critical rhetoric, discourse and genre analysis, and legal history. McMurtry-Chubb is a leader in designing curricula to facilitate diversity, equity, and inclusion efforts. Prior to returning to academia, Professor McMurtry-Chubb was a civil litigation associate at a mid-sized law firm in Des Moines, Iowa. At the time she joined the firm, she was the first person of color ever to be hired there and one of 2 African-American women in the entire state of Iowa in private practice. Amazing. She practiced in areas of insurance defense, employment discrimination, and employee benefits involving the Employment Retirement Income Security Act, otherwise known as ERISA. Before entering private practice, McMurtry-Chubb became the first African-American woman hired as a law clerk for the 5th Judicial District of Iowa. Professor McMurtry-Chubb served as the president of the Association of Legal Writing Directors from 2015 to 2016, becoming the first person of color to ever head a national legal writing organization. She is the author of numerous publications, including the book Legal Writing in the Disciplines, A Guide to Legal Writing Mastery, and is a contributor to Feminist Judgments, Rewritten Opinions of the United States Supreme Court. In 2019, Teri was awarded the 2018 Teresa Godwin Phelps Award for Scholarship in Legal Communication for her article, The Rhetoric of Race, Redemption, and Will Contest, Inheritance as Reparations in John Grisham's Sycamore Row, which was published in 2018. And as some of the students here know, she's also an LS2 professor, as well as doing the elective course Critical Race Feminism. I've only heard wonderful things from all of the students that have been able to participate in her class, and we're happy to have her as a visiting distinguished professor here this semester. Please welcome Professor McMurtry-Chubb.
Hello. Hello. All right, I have some thank yous. I want to thank our wonderful Dean, Darby Dickerson, for creating the environment that helps us to make magic here every day. I want to thank my fantastic colleagues and the stellar students who I've had the opportunity to interact with this year, who have made my time here wonderful. And last but not least, I want to thank Dean Tanya Luma for this opportunity, who I call Dean Tanya Luminous. So, all right, so I come from a culture that utilizes call and response, so I want you to repeat after me. My destiny is tied up in your destiny. So today I'm going to talk to you a little bit about rethinking race, redemption, and reparations. And with most things, I want to start with a story. But the story is about history and memory. So one of the people who is very important in my life and in my husband's life, his name is Dr. U.Z. Brown. He taught us. My husband was a student at Morehouse College. I was a student at Spelman College. And Dr. Brown kind of knew us before we were us. He's known us since we were 18. So when we went back to Atlanta, my husband was teaching at Morehouse, and we decided we were going to take Dr. Brown out for dinner. So Dr. Brown was really excited that 2 former students were going to take him out for dinner, and he promptly told us that he was going to order everything on the menu. He's going to order appetizers, dinner, dessert. We were like, let's do it, Dr. Brown. So we were talking. This was shortly after 2016, and Dr. Brown said, you know, I'm really kind of upset. He's from a small town called Cowpen, South Carolina, and he said people are talking about slavery and Jim Crow, particularly Jim Crow, as if it were history, but this is memory for me. And so I want to talk to you about the tension between history and memory. My first year of college was the year of Rodney King, and I remember my future husband and I, then my boyfriend, were in a classroom building, and I remember looking out over the quad, and there were people running. And they were running because the verdict had just, or not the verdict, that the video had just been released of Rodney King. Actually, it was the verdict that had been released, and there was no exoneration. Everyone thought, you know, this was the video. We saw this man being beaten, and there would be some justice, right? Finally, it was documented, and there wasn't. And I remember, again, I was at Spelman. My husband was at Morehouse. This is the Atlanta University Center, and the Atlanta University Center is in Southwest Atlanta, and it is well, it's been gentrified now, but it used to be it used to be a very white place, then it was a very black place, and now it's back to being a very white place. But at the time we were there, you could only get there through one freeway exit, and so the police had locked down that entire freeway exit, and so nobody was allowed in and no one was allowed out. And there were police in full riot gear preventing us from leaving campus. We had curfews. We couldn't be together in groups of more than 3 because that would have been a gang. So we were on complete lockdown. I remember having this surreal moment where I was looking at the riots in LA, and I was looking out my window, and there were police in full riot gear outside of my window, and there were police in full riot gear on the television. And again, this is not history, this is memory. And then finally, I want to talk about, as a means of introduction, there's a young scholar, his name is Saeed Jones. He is a queer black man. He wrote a book called How We Fight for Our Lives. And he talks about, it's a memoir, and he talks about in the memoir how his coming of age began when he grew up in Texas, and he witnessed the news footage of a man named James Byrd being lynched in the 1990s. James Byrd was drugged behind the back of a car. And then he also subsequently learned about Matthew Shepard, who was a gay man who was suffered a brutal death. And Saeed Jones says, and I quote, "In those 2 instances, I learned that it was not okay to be black or to be gay." So history versus memory. So the handout that I asked Dean Luma to give to you all is a plantation record from the Joseph M. James plantation. And so what we know from historians of the antebellum South is that plantations with 20 or more slaves were the wealthiest of plantations. They had the wealthiest of planters. This particular plantation, Joseph M. James had about 4 plantations. This record is from his plantation called Cookshay. I believe this plantation was in Arkansas. And he had just 50 enslaved individuals on this plantation. So keep that in your head. 20 or more slaves were the wealthiest of planters. We know from historian Edward Baptist and his sweeping muscular history of slavery and global capitalism, The Half Has Never Been Told, that came out in 2014, that slavery was a capitalist endeavor that built a U.S. economy, particularly cotton cultivation and cotton production. And so I want you to think about that too, that cotton, by the 1860s, the U.S. was the global provider of cotton, the global provider of cotton. Another historian, Swen Beckert, puts it in the context of a global economy where Baptist is focusing on production and labor. Beckert is focusing on the U.S. in the constellation of countries that participated in cotton sales and production. So we are the leader. So about this handout. So I want you to look at this handout, again, a plantation record. On one side, you will see the valuation of enslaved individuals on the plantation. And on the other side, you will see how much cotton in pounds, each person picked. So I want to give you some numbers here for context. The value of cotton in 1857, which is what this particular record is from, cotton sold for approximately 12.5 cents in 1857 per pound. This record is an illustration of the amount of cotton picked during this particular week. On the other side, let's see here if I can pull this up for you. For those of you that don't have a copy, I'll pull it up here. So this record is from November 22nd, 1857. And here you see all of the enslaved individuals on the left-hand side and the amount of cotton that they each picked in pounds. So as of this date, November 22nd, 1857, the enslaved had picked 84,326 pounds of cotton. You see this number down here. 84,326 pounds of cotton. Keep in mind, this was just in one field, in one plantation, and Joseph and James had about 4 or 5 plantations. So just in this one field. 84,326 pounds of cotton that went for 12.5 cents. In 1857, the value of that cotton was $10,532.91 in 1857. The present value of that money is $311,000, $396.40 in 2020. So we're talking about $300,000, and the year is not yet over. 84,000 pounds of cotton as of November 22nd. And that's just for one of Joseph M. James's plantations. If you look on the other side of this handout, you will see how the enslaved individuals are valued at the beginning of the year and the end of the year, and their ages and their valuation. So in the 1850s, where you see this huge cotton boom, enslaved individuals were going for the top prices that they would go for during this era. A prime field hand, which was a black man between the ages of 18 and 33, would go for $1,200. This is $1,200 in 1857 money. The present value of that money is $35,000. So $35,000 per person. Huge amount. The total value of the enslaved persons at the plantation in 1857 was $31,900. The present value of that money is about $945,000. So between slaves and the value of cotton at this plantation, as of November of 1857, the present value of one of Joseph M. James's plantations was $1.3 million. $1.3 million. I want to bring your attention to Ella. Ella is 8. At the beginning of 1857, she is valued at $500. At the end of 1857, she is valued at $600. I want to bring your attention to Ella because look at the amount of cotton an 8-year-old is picking in pounds. 30 pounds, 42 pounds, 57 pounds, 62 pounds, 25 pounds, 77 pounds. Ella is 8. And that looks to be the year, at least on the Joseph M. James plantation, that children were put out into the field for labor. So history and memory. So the question is, who bears responsibility? Are only the named descendants of the enslaved deserving of payment for their ancestors' labor? Or are the whole of descendants of enslaved Africans who suffered under the regimes of white supremacy, patriarchy, capitalism, and imperialism deserving of payment for their ancestors' labor? And as you think about these questions, I want you to think about this is a global economy. Cotton built the U.S. economy, the economy that we participate in today. Cotton built this. I cannot stress this to you enough, that financial instruments such as mortgages were created during this time to deal with the mortgaging of the enslaved. This was a credit economy. Contracts law changed between the 1850s and the 1860s and 70s, from a title theory of contracts to a will theory of contracts to deal with expectation damages based on the cotton trade. The commodities market was built on cotton. And for every plantation that was making millions of dollars, there were more than 50 enslaved individuals on them. So who bears responsibility? Who is deserving of payment? So I did extensive research on reparations litigation, on the cases that have been litigated dealing with reparations. And so nomos is the universe in which legal reasoning functions. It is a Western concept that comes from ancient Greek and Rome. And for the purposes of my talk today, it governs the procedural and substantive rules of the game for reparations litigation, nomos. So I want to talk to you about several cases in the litigation universe. And, I have an abiding love for the individuals who brought these cases, but none so much as for the plaintiffs in the first case that I studied, which is called Johnson v. McAdoo. And this case was handed down in 1916. I love the plaintiffs in Johnson v. McAdoo because they were enslaved between 1859 and 1868. And they're bringing this case. So they were children at the time that they were emancipated. And I just admire their swagger because in 1916, they said, look, in 1865, the U.S. Department of Treasury seized and taxed as internal revenue tax on raw cotton that they, these individuals, the plaintiffs, had cultivated and harvested during slavery. Now, I want you to wrap your mind around this. And I wish I had a bigger document camera because I would have brought my book, The History of America in 100 Maps. This is an excellent book, and it has 100 maps that tell the story of U.S. history. My favorite map in that book is a map, it's a military map that was drawn for General Grant. And the military map shows the entire South and charts Grant's march to the sea, but it has pictures of where every single plantation is and every single settlement of enslaved is. And the reason for that is because Grant gave specific instructions to his troops, hands off, because this is money. Don't burn the cotton plantations and don't kill the enslaved individuals. This is important. So in 1865, the U.S. States Department of Treasury seized and taxed as internal revenue tax on raw cotton that the individuals in Johnson v. McAdoo had cultivated and harvested during slavery. They say, so the amount of money collected as a result of the tax was, are you ready? $68,072,388.99. This was 1865 money, $68 million in 1865. And my plaintiffs, my favorite swagger-filled plaintiffs say, you know what, we get an equitable lien on that because we helped to cultivate that cotton. The case originated in the then Supreme Court of the District of Columbia, which dismissed it on the U.S. Attorney's motion to dismiss. And of course, the plaintiff appellants appealed to the D.C. Court of Appeals, which upheld the lower court ruling on grounds that, get this, the plaintiff appellant should have named the U.S. government as a defendant and not the Secretary of Treasurer as the steward of this money. But the catch was that they wouldn't have been able to sue the U.S. government without its consent. So they lose, they lose, they lose. And I'm here to tell you that this universe of reparations litigation is extremely racialized, and we're going to go through that. So in the Greek and Roman tradition, so remember right now we're talking about litigation. So I studied these reparations cases. So in the Greek and Roman tradition, we argue, we're litigators, and we embody either implicitly or explicitly Aristotle's persuasive appeals. So we go through pathos, ethos, and logos. But again, the nomos in which this takes place is racialized. Don't believe me? Let's talk about it. So here are the cases that I studied: Johnson v. McAdoo, Cato, Pigford, Obadell, and in African American slave descendants. Note that from 1916 to 2005, we have these huge, massive cases undertaken in the courts. And so now I'm going to talk about what guided their attorneys and how they made these arguments and why they were not effective. So, pathos. On this side, we have the picture memorialized of Mamie Till bending over the graveside of her son Emmett, who was lynched. Emmett was in Mississippi visiting his grandparents on vacation. He was from Chicago. And allegedly, Carolyn Bryant says that Emmett whistled at her in the store, which prompted her husband and his friend to go out and get Emmett and to tie his body to a cotton gin fan and throw it in the Chattahoochee River. As they were searching for Emmett's body, they found tons of corpses in the river and in other rivers in Mississippi. And these were the men who had been lynched, and nobody looked for them before this point. So Ella Baker, who was a social justice organizer, as she was speaking about Emmett Till, she said, "Until the killing of black mothers' sons is as important as the killing of white mothers' sons, we who believe in freedom shall not rest." And Emmett, there was a lot of controversy about Emmett's body and about getting it back to Mamie and about getting it to her in Chicago. The NAACP had to intervene. And Mamie made the decision at that point to have Emmett's body revealed in an open casket. And the enduring quote that comes from Mamie is, "I want the whole world to see what they did to my boy." And so Emmett's funeral, which again, I wish I had the pictures from Ebony magazine. I mean, it was like, bigger than many celebrity funerals, state funerals, is believed to be the start of the classic civil rights movement. Pathos. Using emotion to persuade. But whose emotions matter? On this side, I have Louis Head, who is Mike Brown's stepfather. This picture is of him learning that there would be no indictment for the police officer who murdered Mike. And when he heard this, there's actually video of him yelling, "Burn this bitch down." And because of this, the prosecutors began proceedings to indict him for the fires that made Ferguson burn. Whose emotions matter? The next Aristotelian appeal is ethos, using character, credibility, and gravitas to persuade. Whose stories do we believe? Here we have Sandra Bland, who was pulled over on a routine traffic stop. She ends up dead in her cell. And the question is, did she kill herself or was she murdered? Who do we believe? Now we have footage that has surfaced from her cell phone, and so we have a better idea of what happened. But remember the controversy in the days following her death. Here we have Eric Garner, and I picked this picture because in 3 frames it shows how quickly the situation escalated. Of course, Eric Garner said his famous last words, "I can't breathe." Look at his initial interaction with the police officer, the forbidden chokehold, and eventually his strangulation. Whose stories do we believe? We didn't believe either of these people. And why didn't we believe them? Lastly, logos. Now this is my Lady Justice. She's not, she's not checking for y'all. She doesn't believe that there is justice. She's a little skeptical. Scales of justice are a little small. She has a lot of swagger about her. And what she wants you to know is this. Logic is based on 2 things. How you know what you know, and how you are who you are. The fancy words for those are, how you know what you know is epistemology. How I make sense of the world is directly related to how I understand my place in the world. It's directly related to my culture. And how you are, who you are, my ontology, how do I believe that I got here? And so epistemology and ontology determine how we build the analytical frameworks and reason to legal outcomes. How the lawyers in the cases that I listed for you were able to argue and ultimately to fail. And so back to this litigation universe, nomos sets the rules of the game. It's rooted in Western rhetoric. But nomo, at the bottom, is from the African diasporic tradition. And nomo is the universe in which invocations for justice function. These are always in conflict because of how we view these things in the racialized nomo. So I want to talk to you a little bit about this concept of ideographs and analytical frameworks. I want you to stay with me here because it's a little heady. So as I'm drafting a brief as an attorney, there are certain landmines, and those landmines are ideographs. And ideographs are words that bring with them all of these modes of reasoning, all of this baggage. So if you think of the word citizenship, right? Citizenship is an ideograph because with it comes all of this baggage about what we think about it. And so when we use the word, no matter what we say after, people are going to have a certain perception of what that word means. Are you following me? So in the reparations litigation universe, using the words slavery, discrimination, bring with them certain set frameworks that the court utilizes in resolving these disputes. Word blocks, if you will. So in my first case, Johnson v. McAdoo in 1916, the Johnson plaintiffs framed themselves and their ancestors as subject to a system of involuntary servitude. Of course they did. They were enslaved between the years of 1859 and 1868. However, in doing so, they implicated slavery as an ideograph that evokes a cascade of beliefs that normalizes people of African descent as laborers and justifies their victimization. So, as an ideograph, slavery focuses the court on systems over people. And you might think, that's good, that's what we want. But the response of the court was to say, because you have now implicated a system, the United States government, and not the Secretary of Treasury, not an individual, then you must engage with the United States government that gets to decide whether you get to sue it for a wrong that you have perceived. So this was the reason why the court said you lose. Because every time you invoke slavery as an ideograph, the court says sovereign immunity and you lose. In Cato v. United States in 1995, the plaintiffs again evoked slavery. And as an ideograph, the court said, fine, now we not only invoke sovereign immunity as a roadblock, but also the statute of limitations, because it's 1995 and slavery ended in 1865. So you have to show that there's a direct line between your wrong that you're alleging and any damages that you want to get. So slavery then invoked the sovereign immunity roadblock and the statute of limitations roadblock. The Cato plaintiffs also argued that they were the victims of discrimination. And the court, discrimination is operating as an ideograph in the realm of reparations litigation. And so the court says, okay, the roadblock we're throwing up for this is political question and standing. Do you have standing to bring this lawsuit? You were not directly enslaved. And the political question doctrine, that this is for the legislature to resolve, not for the courts. So, in every single piece of litigation that I studied, every time the plaintiffs talked about slavery as a system of oppression, every time they talked about being the victims of discrimination, the court said sovereign immunity, statute of limitations, political question, and standing. Pickford v. Glickman is a case that involved black farmers, and the plaintiffs brought the lawsuit specifically under a anti-discrimination statute, And the reason why I say they kind of won is because they got a recovery. The farmers brought a class action suit in Pickford about the number of black farmers that were dispossessed of their land, but they didn't really win. 907,000 African American farms disappeared between 1920 and 1922. And the putative class of plaintiffs in the original cause of action was only 641 black farmers. So if you think about 907,000 black farms and only 641 black farmers, that's not really a victory. So why does reparation litigation fails? Partly it fails because of our understanding of the past and its impact on the present. And so there are these ideologies that drive how the court sees these cases. And one, remember what I told you about the difference between nomo and nomos, right? Nomo is the universe in which invocations for justice function. The African American or the African diasporic experience has with it the overriding belief in perseverance, endurance, and hope. And understanding that there is history and that our history is not behind us, but it is ever present and in front of us, and we are working through it, that it always has an impact on how we live our lives daily. But the white racial recovery rhetoric, the racial recovery rhetoric that the court uses to resolve this litigation is based on honor and remembrance, that history is something that happened in the past. You don't believe me? Honor and remembrance, perseverance, endurance, and hope. Anytime lawyers attempt to connect the present condition of African Americans living in the U.S. to the legacies of slavery and Jim Crow, the court throws up these roadblocks. So I want to read for you for a moment part of the opening words of the briefs from In African American Descendants and Cato v. United States. So in the descendants case, they say, equality under the law and freedom from discrimination are not reparations. They are separate issues from reparations. Their implementation does not provide repair for the damage done, nor restitution for the property stolen. A decision by the representative branches of government does not ipso facto relegate the issue of reparations to their exclusive purview. They're speaking specifically about political question, that you don't get to move this discussion to the legislature, that we can have the discussion in the legislature, but we also need to have the discussion in the courts. The Cato brief reads as follows in their opening brief. This lawsuit is of great historical significance and is long overdue. There is a sufficient precedent for the United States government to pay reparations to racial or ethnic groups that it has injured. Descendants of Native American nations have rightfully been paid millions of dollars for U.S. treaty violations. Japanese Americans interned during World War II were rightfully paid $20,000 each and given a formal apology by the government. Certainly, the plight of enslaved Africans and their descendants, the thousands of dead African bodies tossed into the Atlantic Ocean during the Middle Passage, the billions of dollars worth of free labor forcibly extracted at the crack of a whip, the innumerable rapes and beatings of women and men who toiled for lifetimes in the sweltering heat, the countless crying infants torn from the arms of their grieving mothers, the federal government's abandonment of the survivors of the Holocaust, of this Holocaust, to the mercy of lynch mobs and Klansmen and humiliating treatment based on a theory of racial inferiority, and all the subsequent cases of racially motivated discrimination, abuse, and murder, surely this too deserves an apology and compensation. The court creates a legal fiction about how it has ruled on the merits of discrimination claims and that have dealt with slavery and its ongoing harms, particularly as it relates to black people and white supremacy. But it pushes the responsibility of addressing it as reparations back on the legislature, to the extent that courts actually use history to draw upon in its analysis. It cherry picks. So in the Enri African American descendants case, the court goes into a huge discussion about the Civil War and the history of the Civil War. And it largely talks about it as a military history. And I go into a lot of detail about this in the article. A particular interest to us for this talk is that the court uses only white historians to talk about the history of slavery, except for one exception, when it uses a black historian for the proposition that, you guessed it, Africans participated in the slave trade too. White racial recovery rhetoric of honor and remembrance versus African American recovery rhetoric of perseverance, endurance, and hope are locked in this enduring struggle. And this is why litigation fails in the racialized nomos. So right now I want you to make a conceptual leap with me, which is why I have these pictures here. Anybody know what this picture is? The style is very much of a plantation house. And what I want to talk to you about is our cultural inheritance in the United States. Our cultural inheritance as family. And that when slavery ended in 1865, the plantation, the site of the state shifted from the plantation to the White House, but it didn't really change. Family is understood in the Western world as the normative universe of testamentary dispositions. And so the question I have for you is, who is worthy of our cultural inheritance? Presently, our cultural inheritance of privilege and power, descendants of the African enslaved are excluded from that cultural inheritance. Courts have underscored in the realm of testamentary dispositions that natural bequests are those the testator makes to its family, in the same way as natural bequests in our United States government of privilege and power are those made to family. And the courts have made it very clear that people of African descent are not part of the American family. Unnatural dispositions raise the possibility of undue influence, right? Anyone not a blood relative of the testator is an unnatural beneficiary of his or her estate, even if that person was a caregiver to the testator before his or her demise. So I want you to think about this, right? After slavery, the plantation is a organizing structure for society, because make no mistake, it was an organizing structure for society, transferred to the state. And the state became the master of a nation in which difference was enshrined in our founding documents and reflected in our lived experience. Who is in the American family? Who is a natural recipient of our cultural inheritance? So I want to talk to you a little bit about our will. You could think of the Constitution as our national will, right? The will as a document is a personal narrative, and it is central to the process in which an individual confronts his or her mortality, assesses their life accomplishments and disappointments, and contemplates his or her legacy. In this regard, the will is a story. It's a story that the testator tells about his or her life through the language of the will and those things the testator gives at death, to whom the testator chooses to give them, and the people to whom the testator chooses to give them. This narrative becomes contested when the person is not family. When a testator disinherits the testator's heirs by failure to give them any of the testator's estate, the disinherited resorts to litigation to contest the will, primarily under the legal theory of undue influence. A narrative that the testator tells about his or her life through the language of the will and those things the testator gives at death and how the testator chooses to give them and the people to whom the testator gives them. Think about freedom in this respect, right? Freedom via a will, or freedom for the formerly enslaved. This process involves taking something away from someone and giving it to someone else. And isn't this what we're talking about when we talk about reparations? That the biggest barrier, the biggest debate is, I was not the owner of slaves, and I will tell you, I was never a slave, and yet here we are. But just as in the realm of testamentary dispositions, when we take something away from someone who is family and we give it to someone who we don't think is deserving, there's a will contest. And right now we're in a will contest over our cultural inheritance. And someone's going to have to give up something or be forced to give up something in order to give back to the people who built this country, who built this economy, who built a global economy. So when I was writing and studying about this, I was contacted by several attorneys who had litigated will contests based on dispositions that were given during slavery. So basically, descendants of enslaved people came to them and said, "Hey, we found this will in these papers, and it seems that our relatives were given their freedom via will, but the family just conveniently forgot about it." And the question then became, so what do we get now? Because I'm here to tell you that the descendants of Joseph M. James, his legitimate or illegitimate children, there are no illegitimate children, only illegitimate parents, but his children, the enslaved that worked on that plantation, that $1.3 million, people, 1.3, that's a heck of a start in life, is it not? And I can tell you through my research that this money was rolled into corporations that are now Fortune 500 corporations. This money was rolled into families who are now the leading families. And so when we all look around and we say, this is for the legislature, I'm here to tell you it's not for the legislature, because we can draw a straight line from these records to who's benefiting now. So again, in the reparations contest, the will is a cultural narrative. And right now, African Americans are outside of the family created at the founding of the country. Remember, if you read Dred Scott v. Sanford, and the court says that African Americans were not intended, were not meant to be included in We the People. A reparations appeal to the U.S. government is akin to a claim of undue influence of the paternal master, the testator. And we will lose the will contest every time when we were sent to a Congress who refuses to discuss the matter at all. Congress refuses to discuss the matter at all. So it's up to us to reshape our cultural inheritance. And this is what I propose. This is how I propose we move forward. We have to take responsibility for the legacy of slavery as a country, and we have to reshape who is a beneficiary of our cultural inheritance and who is in our national family. Or if we don't take responsibility, then we need to have that responsibility thrust upon us. So social media has been instrumental in exposing people doing dangerous racist acts. Why not use it as a vehicle to expose family and corporate wealth rooted in enslavement and tie it to it directly? And I have tons of records. My friends laugh at me. I have tons of plantation records. I carry them in boxes every time I move to a new state. Recently, they were digitized. Thank you for my research assistant. But I have them. In fact, the record that you have is one that I carry with me on my iPod, and I have it in airports, and I talk to people. I say, hey, want to see a plantation record? I stopped doing that because people start crying, and then I don't know what to do. Because it is evocative, right? But even though litigation is ineffective, it can be effective to bring attention to an issue. And so when I file a complaint, it becomes a matter of public record. So I'm willing to file a complaint using an extensive amount of slave records and calling people out for their wrongdoing, for their ancestors' wrongdoing, and for their unearned benefit that they got from people like Ella, who at 8 years old was picking on average 50 pounds of cotton a day. My proposal is meant to influence public perception and understanding about the impact of slavery and Jim Crow. Because as Dr. Brown said, this is not history, this is memory. So in closing, our destinies are bound up together We can continue to rip each other apart or reckon with our past and make things right. Thank you. So are there any questions? Comments? I know this is heavy. Yes.
Hi, I'm Kashmir. My question is, in the recent cases that you talked about, asking about reparations and how the court said that they couldn't take them because of political question, how did they reconcile that with the Dred Scott case if they've already dealt with a case about slavery? How can they say it's now a political question when it wasn't then?
Because the court creates this legal fiction that history is in the past and it has no bearing on our future. So it silos it there and says that that happened then, but this is something different now.
Okay.
So it's an understanding that it chooses to advance about our history.
Okay.
But in reality, we know that's not the case. Yes?
What about seeking reparations from more recent and ongoing harms like the fallout over redlining?
Yes, and again, the court in McCleskey v. Kemp, the United States Supreme Court lays out the parameters for using historical documentation as a persuasive tool. And essentially what it says is there has to be a straight line between the harm you're alleging and the present damages, and that you have to bring history contemporaneous with what's going on now. So in order to bring a successful lawsuit, you would have to show that for every year since you're alleging that redlining happened, that you have to show how it continued to happen for your plaintiff in their particular area and the impact that it's had on their family. And the reason why most attorneys won't do that is because, one, they don't know how to access those resources to do that. Two, it takes a tremendous amount of people power to create such a document. So the court has basically kind of, put the kibosh on how we are allowed to litigate using history. I saw another hand somewhere. Yes?
Recently in the news, there was discussion of reparations, even a hearing of it, and there were many people that spoke on reparations presently and in the modern day sense. I'd love to hear your opinion on that, and also if you see any further resurrection of reparations on the Russian Republic.
Yeah, I mean, I think that a lot of the discussion is well-meaning but wrong-headed. I mean, part of my husband and I joked when I was preparing this talk, and I said, I always give my talks two titles, one for you all and one for me. The title for me was "Run, Cut Me My Check," and so the reason why I think it's wrong-headed is because we're talking of reparations in terms of, we should implement these social programs, and we should, make sure people have affordable housing, and that's great, but run, cut me my check, right? Like, this is real. This is actual money. This is actual money that I can trace. So yeah, I think we should be talking about both, but I think we should be talking about actual checks, actual money. Because one plantation, $1.3 million in 1857, and we're still almost 10 years until the end of slavery? Come on. $68 million in 1865 that the U.S. government taxed and seized? Come on. I mean, the plaintiffs in Johnson v. McAdoo had it right. Where's my equitable lien on this cotton that I helped to cultivate? Mm-hmm.
So just to clarify, when you use this wills analogy and unwilling, is the remedy to take that from the government, or where is the money coming from?
The people who actually benefited from it. I want to go after I want to go after corporations. I want to go after the families that have benefited from this money.
Right. Based on letters and things like that. Okay.
Yeah, and what most people don't know, because we don't teach this to you all in school, is that there are thousands of these records, thousands of them. And I am just stubborn enough that I have gone through thousands of them. I spent 2 years in the archives looking at these things until I went, like I had to go to the eye doctor, and they were like, stop looking at records. But this is real. Also, I want to add too is that not all white people are included in our understanding of American families. So a book I'm working on right now deals with Southern overseers. And overseers were a class of poor whites that worked on plantations. And what I found in my research is that overseers signed contracts with planters. Overseers were always white men who signed contracts with planters for their employment over the course of the year, and the planters never paid them. So it's years and years and years and years, and after every year, they're like, oh, by the way, we don't have enough money to pay you, notwithstanding this $1.3 million I just made. But you keep working on the plantation, and maybe one day we'll settle up. And so my argument is that you get a claim too. Because if your ancestors weren't paid for their labor, you get a claim too. Because we can prove that too. I have those records.
Did you find in your research that there were people who destroyed records so that it was not available for something like this to end up happening?
No, what's really funny to me is that everyone thinks that like Nazi Germany, cornered the market on documentation of a Holocaust, but these planters were the template for Nazi Germany. And so these records are as specific as any records that you would find out of the Third Reich. And this is just like I pulled the ones that were just, viscerally that you could understand. But in this is a whole plantation accounting book. So think about it. The overseer is, at the end of the day, all the enslaved individuals are coming up to the overseer, getting their bags of cotton weighed. The overseer is writing this down in the ledger, and then calculating how much cotton was picked the week before and adding it to the amount of cotton picked in that present week. But in addition, the overseer ledger book has notes on each enslaved individual. So the overseer will say, well, Amen was a little slow this week. He got a slow start. He picked 106 pounds of cotton. By Thursday, he picked 147 pounds. And maybe we should increase the quota to 300 so we can push him. And so there's like all these notes that the overseers took on each enslaved individuals. There are notes about each task that they were set to. I study exclusively cotton plantations, partly because of the role of cotton in the global economy, but also because it was a specific system of labor, a gang system of labor that lent itself to certain consistencies and continuities. But, they didn't destroy them. They were proud of them. In fact, George Washington made one of the first plantation management books. And in it, he talked in glowing terms about the overseer walking out the footsteps of the planter and the interplay between the two. And so many of the people who are called the founding fathers of our country were responsible for this whole regime of plantation management. And in the management discipline, overseers were the first group of salaried individuals in the United States as managers, if you can think about that. So again, this whole regime sparked ways that we still deal with management of labor today. And make no mistake that as managers, cotton is unique in that it requires you to pick it, and then it has to be processed before it can be sold. And you can have as much land and as much labor as you want, but the productivity of the labor is what makes the difference between how much money you're able to make. So overseers were experts in the use of torture and getting enslaved individuals to work faster. And so this is what this whole regime was based on: the torture, death, maiming of a workforce to make them as productive as possible. And I don't know if you've ever seen a cotton plant or if you ever just held a cotton ball in your hand. 267 pounds of cotton, that's a lot. And to do that in one day. Mm-hmm.
Professor, I understand going after, for instance, the Brown family out of the Northeast or Aetna, but what about the federal government? As you pointed out, the federal government paid reparations for Japanese folks that were in internment camps, at least during that time period. The federal government paid reparations for Vietnamese soldiers who worked with the federal government, at least during the Vietnam War. And make no mistake, slave labor helped to build the Capitol building.
Absolutely.
So why not? And I want to come back to this, that in those instances, the entire nation paid.
Absolutely.
Even though I didn't do anything wrong to, intern anyone or to put anyone in an internment camp. So I'm just curious as to why not at least hold the federal government responsible.
Yeah, I'm not ruling it out, but I'm just thinking strategically in the economic and political climate in which we find ourselves. I think it's a non-starter, but I'm not against it. I mean, I think that strategically, yes. And if they want to throw up the roadblock of political question, well, let's engage the political question then. But you're absolutely right that the government $68 million was not going to the people in 1865. So yeah, I agree. Mm-hmm.
I remember a couple of decades, like in the late 90s, it came out that Ford was profiting off Auschwitz, like, labor, and I'm not really familiar with the case, so I believe it was thrown out. And I was wondering if you were aware if that, was the same rationale for the other reparations cases.
Mm-hmm. Yeah, I mean, all of American industry, what we think of as the hallmarks of American industry, was built on the backs of this suffering. And I think it's a lot to wrap your mind around to think about the U.S. as a global leader in cotton production, and all of that is because of enslaved labor. The economy that we currently exist in would not exist but for slave labor. The financial instruments that exist would not exist but for slave labor. So when you think about it that way, it's built into the fabric. Cotton, I used to have a lecture called Cotton, the Fabric of Our Lives. It is literally the fabric of our lives. I have another lecture called Sugar, the Crack in the New World. Same issue, right? That it is the sugar plantation. Sugar was like crack, right? And sugar plantations killed labor. I mean, the life expectancy of an enslaved individual on a sugar plantation is 10 years. That's it. And enslaved individuals, because the slave trade, the transatlantic slave trade ended in 1808, we've got labor being driven down from Maryland and Virginia to Georgia, Alabama, Arkansas, Tennessee, West Virginia, to work on cotton plantations to fuel this world economy. Mm-hmm.
I'm just wondering, who would get the money? Would it be only descendants of slaves? Would it be blacks that are not descendants of slaves? Or, for instance, what if they're mixed? Like if I married somebody who was a descendant of a slave, would my wife get the money and also my child, but not me?
Yeah, I mean, everyone in the African diaspora, so all African diasporic people, because the slavery existed. Another thing that you all don't learn is that slavers were really, they understood that there were specialized labor forces on the continent of Africa. So they went to specific countries where cotton was being cultivated and indigo was being cultivated, and took people from those places. And so if you go to the African American History Museum in DC and you start out the tour, you will see the impact of all the countries in the world, primarily Europe, had in their participation in the slave trade. And so this was a global economy. There was no North and South. They were all complicit. So yes, African diasporic peoples. Mm-hmm.
So you went over who would get the money, or where the money would come from, so that would be people who benefited from this money. What type of act do you think has to be made, or law that has to be passed in order for reparations to really start happening? Or can you tell me who you think should make this act a law?
Well, when I did this, I was kind of depressed after studying these cases, because I thought there's no way because these are the roadblocks that are thrown up for litigation. So the short answer to that question is, until we grapple with the fact that history is not history, it's memory, then we can't get any further. So any discussion of an act or even successful litigation is premature, because we're still locked in this struggle over history and what it means to us today. So until we get past that, the courts are not going to help us, and neither is Congress. I think we're at time, but I'll take questions if, yes.
Well, since you talked about how it impacted the global economy and how, the globe benefited it, and the African slave trade was international, not just in the Americas, but South America and, the Caribbean, do you think maybe this should be more of an international issue where the whole world can be held accountable?
That would help. Would be a start, yeah. But yeah, yeah, I think so. All right. Thank you all for coming.